All right, so as I was saying, we're going to be speaking for 15 minutes each, and then we've got a 15-minute question period at the end. Janet is going to be talking about the challenges facing unions in the near future, including demographic trends like an aging workforce and a more multicultural workforce. And that leads into a discussion about human rights, which will be led by Lisa Triano. Lisa is going to talk about the basic concepts of human rights law, such as what is a disability, what is discrimination, what kind of discrimination is prohibited, what is the duty to accommodate, and how you actually make a human rights claim. Finally, I'm going to be speaking about the duty of fair representation as it relates to human rights issues in a workplace environment. So I'll be talking about why labor boards hold union representatives to a higher standard in human rights cases and how you can meet that higher standard. When we get to the Q&A portion, you can submit questions verbally with your microphone if you have one. An internal microphone doesn't work well, so we probably won't hear you unless you're using an external microphone or headset. But you always have the option of typing your question in the chat box at the bottom right hand of your screen. And you'll also see, well, there's a way to raise your hand to signal that you want to ask a question, but I'll go over that at the end. So I know you're all very busy people, so we're going to try and stick to our 1 hour schedule, and we'll get started. I'm just going to make Janet the presenter so that she can speak and go through her slides.
So I'm joining you today from Saskatchewan. Just got off a plane less than an hour ago and scrambled over to my client site. So if you see someone taking notes in the background, that's actually one of the clients I'm working with today. She's not taking notes about you. She's taking notes as if just participating in the webinar like everyone else. Carolyn has asked me to talk about some of the challenges facing unions going forward as our workplaces change and evolve and as we grow into modern unions. And there are really 5 challenges that I tend to focus on. We're going to be looking at 3 of them today, and I think Carolyn had mentioned to me about saving the other 2 for future webinars if people are interested in doing that. So I'm going to be covering the first 3 that you see on the screen here. We're going to be looking at non-traditional workforces and how we define those in Canada and how those, what some of the implications are for unions, for your membership, and for the workplaces in which they participate. We're going to look at the multi-general workplace and the 4 generations that are currently in the workplace. And then finally, we're going to look at autism and some other learning challenges, or whether they're developmental disabilities, cognitive disabilities, or physical disabilities, but how getting a bit of feedback from somebody maybe moving a microphone around. So let's start with the non-traditional workforces. And a couple of just sort of statistics to get our brains warmed up. Canada is the fastest growing of the G8 countries, and our population is at about 33.5 million people at this point. Having said that, we're still the smallest of the G8 countries. The Yukon has had the highest rate of population growth since 2006, so I'm not sure if that's an area that you have members in, but certainly it's an area of opportunity for Canadian workers and for Canadian unions to be able to represent workers in those areas. There's a lot of growth going on in the north, particularly in the construction industry and mining and gold and diamonds and things like that, but also all of the industries that support those communities as they grow, even if they're they're there for a period of time temporarily while they're mining the natural resources. Entire communities grow and have to be built in those areas. Canada's population has almost doubled since 1961, and most of our population is currently residing in Toronto, Montreal, and Vancouver. It accounts for 35% of the Canadian population spread across those 3 centers. Our population growth, despite all of that, though, is less than 1% per year, and that's a trend that has been steadily on the decrease over the past decade. So you can see that in 2012, our population growth was only 0.78%. Now, this is due, one of the big reasons is a decline in fertility rates of Canadian women. Back in the 1950s, the average Canadian woman had 3.9 children. In 2011, that is now down to 1.7 children. And this decline in fertility rates coupled with an aging population means that our population growth rates are much lower than they were 50 years ago. And we're seeing that trend on that previous slide where our growth just sort of continues to get tiny bit smaller each year that we go forward. Now, you may, depending on what industry you represent workers in, you may find yourself and them in sunrise, sunset, or stable industries. Sunrise are those in the growth area. These are new economies that are being created, a lot of stuff going on around sustainable energies nowadays, and anything to do with green is on the sunrise side of an industry. There are certain industries that you would say are diminishing, that there are fewer jobs in those industries. Those are in the sunset. And then you might find that you're representing workers that are in fairly stable industries. If you are working with your members are working in sunrise or stable industries, then chances are at some point you may have already recognized or experienced a shortage of workers. And we've heard for the last at least decade about the shortage of skilled workers in industries and the impact that that's having on those industries. So depending on where you are, you may have felt this already, or you may see it on your own horizon in your industry. Now, when we talk about non-traditional workforces, we have to look at, we said that there's this low population growth, and yet there's this sort of shortage or gap when it comes to workers. So where will the workers come from? Where will we find these people to actually take the jobs? And so we have, when you look at Canadian literature, the three non-traditional workforces that are typically identified are women. Despite the fact that women have been in the workplace for decades now, we're still considered a non-traditional workforce, as well as internationally trained workers. Sometimes you might also see it written as foreign trained workers. And the third is Aboriginal workers. So let's start with women. Women make up 48% of Canada's workforce and approximately half of the population. But they are underrepresented in traditionally male-dominated industries. So the question to ask yourself is, what is the gender breakdown of your particular membership and the industries that they're working in? I worked with one client recently where they are in a very male-dominated industry, and when they do the stats on their membership, 80% of their members are male. So that's quite out of alignment with the Canadian population. And as best you can, you should try to have your membership reflect the Canadian mosaic, whether that's gender or different cultural backgrounds. Now, when more women come into a traditionally male workplace, it doesn't come without its problems sometimes. And I'm not saying don't include women in a traditionally male workplace, but stuff happens. And in one case that I know of recently with one of my clients, they had a situation where a guy grabbed the derriere of a woman as they were going into the workplace. Of course, she was not excited about this having happened. She was quite offended by it. He said it was nothing. So now you've got two members who are at odds, a conflict between two members. And of course, the next step that happened is people in the workplace took sides. So some people said she was overreacting. Some people were offended at what he had done. But the long and the short of it was, is you no longer just had two people in conflict. You now have an entire working unit of people in conflict. So you have 10 or 12 people upset and taking sides. And this can give rise not only to conflicts in the workplace, but, different, grievances that end up being human rights cases and litigation. I'm going to leave that to Carolyn and Lisa because they're the experts on those kinds of things. The space that I play in is the preventative care or preventative medicine types of things, and the things that you do as the workplace mosaic is changing to help offset or minimize or mitigate the risks of conflicts. Carolyn and Lisa are the ones that sort of handle it. Once it has gotten to the conflict stage, they're the ones who can advise you what to do next. So going back to some of the women's stats, I want you to think about what gender-related issues are already giving rise to conflicts in your workplace within your membership and the workplaces where they're operating each day, and what kinds of training and support do you need to provide to your members in order to create workplaces where women are treated with respect, and particularly if you are representing workers in industries that are traditionally male environments, what can you do in advance to try and lessen the potential for conflict to create awareness and a healthy, respectful workplace? Now, back in the 1990s, I was involved in a really big project of a company. There were 40,000 people, 40,000 members organized into 2 different unions. And you might remember, if you're as old as I am, you'll remember that in the 90s, this word called respect in the workplace was new and it was in vogue. And one of my tasks was to go around this company and provide these half-day respect in the workplace workshops. And I did that faithfully. And at the end of it, I thought, it's not really going to make the big difference because you go in and you're there for half a day and it's all wonderful and you lay out a bunch of information, but it really doesn't change people's lives. What you need to think about is how can you take changing the culture in your workplaces and within your membership a step further beyond just the typical 3-hour workshop or 1-day workshop. What do you need to do that's systemic in order to change the way people think about and view others who have not been in their workplace in the past, whether that's women or other cultural groups or people with disabilities. I want to give you an example of the difference between a workshop and a systemic plan for change. My son has high-functioning autism. I'm not sure if any of you are familiar with that, but the way I discovered it was when he was only a couple years old. I realized that he wasn't talking, and so I quickly hired a speech-language pathologist to come into our home, and she came for 1 hour a week, and I would sit back in the living room on the couch and watch everything she did, just like a sponge, trying to soak it all up. And then when she left, I would practice and I would do everything she had done 24/7. Now, within about 6 months, my son's language totally caught up, and he has actually become very articulate. But the real difference was not the 1-hour workshop that she delivered to him every week. It was the other, hundreds of hours a week that he and I interacted, and I reinforced those lessons and messages that she introduced during that session. So when you're thinking about how do you change the culture of an organization or a group of people, you're talking about long-term systemic change and a series of activities that have to happen over and over again in order to change the culture. There's no workshop that is going to be the magic pill or the magic bullet that's just going to make it all, perfect. So whatever you choose to do has to be meaningful and has to be over the longer term. Let's go on to internationally trained workers. There's much competition these days amongst all of the industrialized nations. There are some very skilled, very intelligent, very well-educated people being trained in other countries, and many of the industrialized nations are vying for their attention. So it's not just that we want them to come to Canada, but there are many other countries that also want them on their soil as well. There are labor shortages, not just in Canada, but elsewhere. And so we need to find ways to recruit and retain well-educated workers. In fact, if you think back to what our population growth, our natural population growth is, the prediction is that by 2020, immigration will actually account for 100% of the net labor force growth in Canada. It's already at 2/3. So if you think about this, we say that we have a very tiny population growth from natural means within our country, but we do have this labor shortage. And in fact, even with medium growth over the next 50 years, we expect that we will need an extra 52 million workers. That's 500 million additional workers. Well, where is that going to come from? Canadian women are not having enough babies to fill that gap. And so one of the places that they're going to come from is foreign trained workers. Now, my grandfather actually brought his family to Canada. My family grew up, was born in Scotland. And just after the war, he was a master electrician, and Canada was looking for skilled tradespeople. And it was the ticket to a new world, basically, for his family. So he brought himself and my grandmother, my mother, and my aunt, and immigrated to Canada. Just after the war, at that time, immigration came primarily from Europe. But today, immigration comes primarily from Asia. So very high chance that your mosaic of your membership will be increasingly Asian in nature. Of course, we're having immigration from elsewhere, but there's it's fairly heavily Asian-oriented at this time. Think about this. There are more people live in the city of Tokyo than in all of Canada. So imagine for a moment a map of the world. Think about the tiny speck on that map that is Tokyo. think about the great big area, the big land mass that is Canada, and imagine for a moment that there are more people in that tiny speck than there are in all of that great big piece of land that we call Canada. It kind of makes me think of that movie, Horton Hears a Who. I don't know if you've seen that with your children at some point, but there's this little elephant, and he hears a voice from a flower, and he leans into the flower, and in this tiny little speck exists the entire city of Whoville. It's a good movie if you haven't seen it, but it's the same kind of concept. There's so much going on within that tiny speck. Token is a tiny speck compared to Canada, and yet a powerhouse when you compare our populations. So with respect to internationally trained workers, how can your union assist internationally trained workers? Is your membership welcoming to internationally trained workers? Once they get into the workplaces, are they accepted and welcomed into the workplace or not? And how can you help them integrate into society and into your workplaces? Because they make a big move when they move halfway across the world. We need to do everything that we can to make them feel welcome and supported and able to function well as members in the workplaces that you have bargaining arrangements with. The third non-traditional workforce is Aboriginal workers. The Aboriginal population is the fastest growing cohort in Canada. So while the average Canadian woman has 1.7 children, the average Aboriginal woman has more than that. So it's just if you segregate or segment the different pieces of the Canadian population, the Aboriginal population is growing at a faster rate than the non-Aboriginal portion of our population. Despite this, they are underrepresented in the labor force, and this has been traditionally due to low levels of formal education and a lack of work experience, both which hinder their participation in the Canadian workplace. So the question I would ask you is, how can your union contribute to the successful integration of the more than 600,000 Aboriginal youth who will enter the Canadian labor market between now and 2026? It means they will come of age, and we need to have jobs for them, and we need to set them up for success so that they can fully participate in the Canadian economy. What steps do you need to take now as a union in order to enable that? All right, let's move on to the second of the three things I'm going to talk about today, and that's the multi-generational workplace. The mosaic is made up not just of different cultures, but of different ages of people. And for the first time in history, we have 4 generations in the workplace currently. We have, and you'll see them called different things in the literature, and sometimes even the years are not exactly the same, but these are sort of a generalization. We have what we call the traditionalists, which are 65 years of age and older. They just don't want to leave for whatever reason. It may be that they just love working, or it may be that they haven't put enough savings aside and they really can't afford to retire, but for whatever reason, they want to continue past the age of 65. Then we have the baby boomers, 48 to 65 years of age. We have Gen X, which is 32 to 47, and then the millennials, the youngest people in the workplace, the 16 to 31. Now, you might notice that Generation Y has dropped out of the terminology somewhere along the line. I noticed last year that we stopped referring to Generation Y. I'm not really sure why, but Generation Y fits kind of somewhere in between millennials and Gen X. I read one story that said that they were the forgotten generation, so it's kind of ironic that they're now, that entire label of people is being just kind of dropped out or forgotten from the literature. Each of these groups comes to the workplace with a different set of expectations around a number of different areas. So things like work methods, rewards and recognition, and the expectations around those, the hours of work, communication expectations, leadership styles, and participation. So let's look at each one of these. In terms of work methods, it's easy to assume that the younger you are, the more tech savvy you are. In a lot of cases, that is true. But I had a situation recently where I have a group of members who are retired from their working life, but they still participate in the union on a retirees committee. And they had to make a presentation. Now, you can imagine they're all 80 plus. So they had to make this presentation. They had to use PowerPoint, which was a brand new experience for them. So I helped them with that. But beyond that, we actually joined together by webinar, just like we are doing today. Now, it did take them quite some time all to get logged in. It wasn't quite as smooth as it was today. But my point is that just because people are older, don't rule them out as being tech savvy or at least interested in learning. Not everyone feels that way, of course, but there are many who do. And in fact, I read something about Facebook recently that said that the baby boomers are the fastest growing group of Facebook users. Let's look at rewards and recognition. The younger people in our workplaces these days have grown up in a time when, and maybe you've experienced this yourself if you have a child who's maybe on a soccer team, but where everybody gets a ribbon or everybody gets a trophy, everybody gets some sort of reward, and there's no winners and losers. So now when that plays out in the workplace, those same kids who've grown up always getting a ribbon are in the workplace and they're always looking for the recognition. And sometimes that can create conflict if they have an older supervisor or there are older members around them who think they're, babies because they need a different level of recognition than they need. And I'm not trying to be judgmental or say one is right or wrong, but they're different. And when there are differences in expectations and what people think needs to be the case, that's when conflicts arise. And so, again, going back to helping people understand the difference or the mosaic of the workplace and how it's evolving goes a long way to help reducing the potential for conflicts and mitigating some of your risks. Hours of work is another one. Millennials and part of Gen X grew up with parents who were workaholics, and many are now saying, I'm not going to do that. And so they expect to leave on time every time, 4 or 5 o'clock, whatever is designated. And they may leave behind some baby boomers who have been accustomed to staying until the job gets done. Now, this is a bit of a broad generalization, of course, but that's one of the things I'm seeing in the workplace is that there's a difference in expectations. Some will say, we're going to stay until the job is done, and others are saying, well, you know what? The job will still be here tomorrow, and we'll get it done then. And it's not exactly defined by each generation, but I am seeing a lot of difference between those sort of new to the workplace and those who have been in the workplace quite some time. Communication expectations are another one. Millennials in particular, and as well Gen Xers, expect to have a lot of input into decisions that affect the work that they do. They expect frequent two-way communication. Some of the older generations may have grown up with a lot of command and control types of leaders and supervisors, and so information was pushed one way in one direction for the most part. That's not what the new generations or the younger generations expect. They expect to have more collaboration and a frequent two-way flow of information, particularly if it impacts the work that they do. Leadership styles is another one. Autocratic versus participative. Those who came into the workplace just after the war, again, a bit of a generalization, but a lot were accustomed to leading in an autocratic kind of command and control type of way, and the younger generations are looking for a more participative style of leadership where not only are they you have the frequent two-way communication, but they're involved in decision making, they're consulted on a regular basis, they're given more freedom to do the work, sort of set the boundaries and then let me go and get the job done within those boundaries. So that, again, can create some conflicts between members if you have one person with a set of expectations around command and control and someone else who expects this world to be participative. And it can create difficulties between members and employers who, are not maybe as aware of some of the generational differences in leadership styles or the generational expectations around leadership styles. And finally, participation. I have a story to tell you. I'm actually on sort of the edge of Gen X. I'm not quite old enough to be a baby boomer, but I'm certainly old enough to be at the top of the Gen X scale. And back in the 90s, I moved from one organization to another. This is a job performance review form, not a particularly good copy of it, but that's what that is. And I had been in a very participative organization, kind of led by, people all my age. And then I went into a more traditional organization. And the first year that it was time for my review, your performance review, I went into my boss's office at the designated time, and I had my form all filled in. I had downloaded it from the internet. I had filled it all in. It was all ready to go. And now she pulled my performance review. And I said, oh, what's that? She says, oh, well, I did your review. I said, well, how did you do that? She says, well, that's what I'm supposed to do. And I said, well, how could you possibly do my review? You don't live in my skin. You're not with me 24/7. You don't really know what I do. And so it was a bit of a learning experience for both of us. She sort of said, well, that's a good point. How else would we do it? I said, well, I've got it all filled out here for you. So in the end, we both took our versions of my performance review and mashed them together, and that became my performance review. And, mine was far more detailed than what she had been able to provide. But my point is that Gen Xers and millennials expect to be involved in decisions and things that affect them personally or affect the work that they do. And so it never even occurred to me that someone else would do my review for me, because how could they possibly do that? So again, she was very open to it, thankfully. Not everybody would be, but something to think about within your membership and when they're working with employers. Now, this is an excerpt or a page from my book, Let's Talk Team Building. I want you just to focus on the quote at the top. It says, respecting another person is not just about using polite language and good manners. It requires you to truly try to understand another person's point of view, even when it differs significantly from your own. And that would apply whether the differences are gender-related or whether they're culture-related, or the last point we're going to talk about is those with disabilities of one kind or another, autism or other learning challenges, or physical disabilities. Autism is not something new. It was identified back in 1943. It's considered to be a lifelong disability with no cure. The incidence is 1 in 88 or 1 in 58 males. So chances are members who have autism, whether they're male or female. There's been a 600% increase since 1990, and nobody's really sure whether it's because we have better diagnostic tools in place, or whether there's actually an increased incidence of autism. But it creates a developmental disorder in 3 areas of deficit, and you'll hear words like high-functioning autism or low-functioning autism. You probably have some high-functioning athletes in your membership now. And they typically have difficulties in 3 areas. One is social reciprocity, which is forming friendships and maintaining friendships in the workplace. The second one is communication difficulties, which may manifest itself when members are communicating with each other, or when members are communicating with employers and kind of get themselves into hot water because they say the wrong thing or they don't say it the way they meant for it to be heard. And also repetitive behaviors or restricted interests. My son's really into architecture, and he could talk about it day in, day out, all day long. And I have a lot of patience for it because I'm his mother, but someone at the lunchroom table may not have the same level of patience for another member, and it can create conflict. All of these things can create conflict. So there's implications with member-to-member interactions and with member-to-employer interactions, but unions are a wonderful place for people who have any of these challenges because there's a built-in social support system through the stewards and health and safety reps that can help them manage their way through the workplace effectively. And it would be something to think about is, do your stewards and health and safety reps have any kind of training in disabilities, not just physical disabilities, but how to recognize what's going on with a member and recognize that maybe they're not just a pest, they're not trying to be annoying, but they actually have some of these things going on. Members may or may not even have a diagnosis, and they may or may not self-disclose, but it's worth your stewards and health and safety reps having a bit of background in this. Also think about the implications of your benefit and health plans, because people with disabilities tend to have higher needs in terms of accessing the benefit plan. So think about that in your negotiating and your bargaining. Last point, avoid forcing strategies that require people to comply and play nice with others, and instead develop an inclusive membership where differences are seen as a strength. And that is it, Carolyn. I'm going to turn it back over to you.
Okay, thanks very much, Janet. And now I'm going to turn it over to Lisa.
Welcome back to our boardroom. Thank you, Janet. As you know, this is our first webinar, so we appreciate the patience of getting accustomed to the technology. What I will start with today is a basic introduction to the human rights legislation and the protection that it offers workers. In Ontario, as many of you know, we're governed by the Ontario Human Rights Code. Federal workers, and I believe we have a few federally regulated viewers tuning in, the governing legislation is the Canadian Human Rights Act. Both pieces of legislation are similar and both aim to provide protection to individuals that have been marginalized or discriminated against. The slides you'll see today for ease of reference are PowerPoints that hopefully are appearing on your screen from the Human Rights Code. Section 5 of the Human Rights Code provides the list of protected grounds in employment. And just a note of interest, the Ontario Human Rights Code was the first human rights legislation in Canada. It was enacted in 1962. The goal of the legislation was aimed at protecting individuals from discrimination and harassment in a number of areas, including employment, which is what we will focus on today. The prohibited grounds have expanded to 17 enumerated grounds of protection. Some recent inclusions are gender identity and gender expression following the addition of sexual orientation. Section 10 of the code provides a list of definitions. Do we have the... Sorry, folks, we're trying to switch slides. Section 10 of the code provides a list of definitions that include many of the prohibited grounds. Today we will not run through or spend a lot of time on what's included in the definition of each of the grounds, but I will address the issue of disability, as the issue of accommodation and disability seem to be a reoccurring theme with our members and our grievances. I will be happy to answer any questions on the other grounds towards the end of the seminar. Disability, through jurisprudence both in the Human Rights Tribunal and labor arbitration, has been defined very broadly. Disability includes any degree of physical, mental, or developmental impairment. We often field questions about whether calling in ill or whether disability has to be permanent or temporary. Disability would include autism, includes alcoholism, includes addiction, and if we get a lot of questions too, if you're sick, if the disability is temporary, it's still a disability. It's illegal to terminate somebody for being sick. And this is one of the questions that Carolyn and I often get. What constitutes disability? What's the scope of the definition of disability? And so in the simplest of terms, if somebody's terminated for being sick, which is referred to as a non-culpable absence, that is illegal. And so we need to process that through a grievance on the basis of discrimination related to disability. The provisions of the code overall are aimed at creating a climate that is understanding and creates mutual respect and dignity in the workplace. Each person in our workplace, each member of our union needs to feel worthy and needs to feel that they are able to contribute to the workplace, and not just, it has to be meaningful contribution to the workplace. The definition of discrimination is not, notably, not defined in the legislation, but it is conduct or behavior, even subtle behavior, that we're trying to switch screens here, bear with us. There we go. So discrimination, as I was saying, is not defined in the code, but it's conduct or subtle behavior that results in, and this is important to try to understand, it results in unequal treatment based on one or more of the protected grounds. Systemic discrimination, a term we haven't heard much of lately, which is also protected in the code, is a type of discrimination that does not recognize individual differences. And what it does is effectively treats everybody the same, but results in different treatment. So an example that I often use when I'm doing stewards seminars or stewards training in explaining systemic discrimination, on the face of an employer's policy or on the face of an employer's rule, it may appear that the policy is fair because it aims to treat everybody the same. If an employer, as an example, if an employer requires all employees to punch in order to get paid, but the punch clock is on the second floor of the building and the building has no elevator, it appears on the face of the policy that the policy is fair because every single employee is treated the same. However, as I mentioned earlier, being treated the same is not always the same as being treated equal. And so in the case of this example, effectively, the employee in the wheelchair would never be able to punch in and would ultimately never get paid. So treating people the same doesn't always mean that you're treating them equally. This is a segue into another area of law that Carolyn and I face a lot, as do the unions every day, is what is the employer's duty to accommodate? How far does that duty to accommodate stretch? Using the example of the individual in the wheelchair in a building that doesn't have a second story. The employer has a positive obligation to assist employees that are either incapable of adhering to the strict policies of the employer or are incapable for various reasons of performing their full duties. The goal of the Human Rights Code and the goal of the protections in the human rights legislation is to allow an employee to perform the essential duties or the core duties of their job. The threshold for the employer to meet this responsibility is very, very high. The Supreme Court of Canada case Mayoran has really, really in recent years pushed the envelope. So the responsibility on the employer to ensure that its workers are capable of performing the essential duties of their job requires them to put into place measures, whether they be physical accommodation or otherwise, could be anything from assistance to physical change of the workplace to modifying work hours, is a heavy burden to the employer with a threshold to the point of undue hardship. So when members approach us about not being able to attend religious services, let's say on a Friday at sunset, the employer is required, and the union, which I'm going to get to in a minute, is required to be flexible with their policies, be flexible with the terms of the collective agreement, and ensure that the workers are provided with the necessary accommodation to meet their needs, including physical disabilities where you may not be able to lift, you may maybe not be able to push, you may not be able to climb. The employer is obligated to provide assistance in order that you can be a productive member of the workforce to get the tasks done. Harassment is a kind of discrimination. Another thing that faces the unions and its members in a very difficult situation is that often, sadly, a situation of harassment, including sexual harassment, is amongst members. And so it's important to know that while it is the ultimate responsibility of the employer to ensure a workplace free from discrimination and harassment, the union also has an obligation to ensure that it participates in being flexible with the collective agreement where necessary. Questions that we face on a regular basis from our office, and I'm sure for the members to you, is how do you characterize a grievance where somebody is being harassed or discriminated against? It's very important to understand that harassment is a kind of discrimination. When I formulate for an arbitrator the scope of the matter before the arbitrator, I always want to try to characterize and have an image that, if you can, discrimination is an umbrella, and harassment is a type of discrimination that fits under the umbrella. It's important when we're formulating grievances, especially if it gets to the point of arbitration, that we recognize harassment as a form of discrimination to allow us to operate with the full possibility of complete argument before the arbitrator. You don't want to isolate harassment from discrimination. There's certain provisions in the code that you ought to be aware of where sexual harassment is a responsibility of the individual. We want to try to characterize, well, that's true, and I'm going to get to that in a minute. We want to characterize harassment as a form of discrimination where we can argue that the employer has failed to provide an environment free from discrimination. In 1992, or in or around there, the Supreme Court of Canada, for the first time, issued an award in the case of Renault, a landmark case for unions, where this is the first time that unions were found as co-discriminators. This heightened the awareness of unions, particularly with respect to liability that they may face when it comes to addressing issues of discrimination in the workplace, and I guess placing a positive burden on us to be aware of the requirements of the Human Rights Code and the necessary flexibility of the collective agreement. In or around that time, prior to that time, and just to back up, prior to that time, arbitrators were not equipped with a full jurisdiction or authority to hear human rights matters. Human rights matters were, as a creature of statute, heard and determined only by the Human Rights Commission at the time. In or around the time of Renault, the Labor Relations Act was amended to include, which is now Section 64 of the Labor Relations Act, that essentially entrenches the Human Rights Code into every collective agreement. This broadened the scope of what an arbitrator may or may not hear. Mind you, in the early days, there was always a battle between the union and the employer as to what exactly was the scope of the arbitrator's jurisdiction to hear and determine and award damages in these cases. The District of Parry Sound ultimately resolved the matter. Now cases proceed through arbitration with the arbitrators equipped with a full authority to decide the case and issue damages as if it were sitting in the trier of fact equivalent to the tribunal. The changes to the tribunal in recent years, as some of us may have experienced, now permit individuals to go directly to the Human Rights Tribunal to formulate what's now known as an application, distinction between what was originally filed as a complaint, this has put, over the years, the union in a precarious situation because the legislation used to require that the grievance procedure be exhausted first, which required us to pay attention to our members, required us to assist our members, required the members to count on the union and trust the union. Now we have individuals with an individual right outside the scope of the collective agreement, able to pursue a human rights issue on their own. And so this creates several complications for the union, primarily because it puts us in a position often of not knowing what's happening, and ultimately, and more often than not, we are named as co-discriminators. And so it's important that we encourage our members to utilize the terms of the collective agreement, to process the grievance for the complaint to the human rights issue through the grievance procedure, so we have carriage of that matter and we can do our best to ensure that our members are protected and we are assisting them through this difficult time. I know that we are coming up close to the hour. Carolyn wants to follow up, and this is a good segue into with respect to the union's liability and human rights issues and multiple forums causing us a great challenge, is a good segue to the duty of fair representation. I think we're going to take questions at the end. I am going to turn over to Carolyn.
All right, so what you see on the screen there is an excerpt from the Ontario Labour Relations Act. It's Section 74 that sets out the duty of fair representation. Under the Canada Labour Code, that would be Section 37. Every province basically has this kind of section in their governing legislation. So the duty of fair representation is pretty much consistent across the country. And what this section says is that unions shall not act in a manner that is arbitrary, discriminatory, or in bad faith. The phrase fair representation, you'll note, is not in the section. It's a phrase that labor boards use to capture all of those concepts: arbitrariness, discrimination, and bad faith. Labor boards, including the Ontario Labor Board, have interpreted the duty of fair representation in a very forgiving manner for trade unions. Labor boards recognize that unions have a very difficult job to do, balancing the competing interests of individual members, the membership as a whole, and the interests of the employer. So they don't expect unions to be perfect. In most cases, labor boards simply look at whether the union made an effort, and generally speaking, if a union rep conducts some kind of investigation and goes through some rational analysis before making a decision, the board will be satisfied and throw out the Section 74 complaint. A union representative really has to be grossly negligent to lose a typical DFR case, that is one without human rights issues. The fair in fair representation has traditionally been interpreted to mean fair as in so-so, not fair as in just and equitable. And that's why the vast majority of duty of fair representation complaints fail. But that may change as human rights issues become more prevalent in the workplace. And I fully expect that they will as a result of the trends that Janet described. You know, I don't know if you have this stat, Janet, but I think it's 1 in 88 kids now being diagnosed with autism. Those kids are going to grow up and they're going to enter the workforce. And we're already seeing more older workers in the workforce, more multicultural workforce, and growing pains as people adjust to those changes. So I expect there will be more human rights complaints from union members. So you should know that labor boards hold union representatives to a higher standard when dealing with grievances that raise human rights issues. And I'm just going to read you very quickly some quotes from different labor board cases. I'll start with one from the Canada Board in Bingley, where this is what the Canada Board had to say. They said, due to the sensitive and important issues associated with the accommodation of disabled workers in the workplace, labor boards look to see where unions have given disabled employees' grievances greater scrutiny and the cases generally concur that the usual procedure applied to other members of the bargaining unit may be insufficient in representing a griever with a disability, mainly because the member's situation will require a different approach. And I'll give you a quote now from the Saskatchewan board, where they said, "We do not think it is unreasonable to expect trade unions to come to terms with the concepts of discrimination which have come to the fore in Canadian society as a result of the passage of human rights legislation, as unions carry out their responsibilities to the employees who rely on them." And this is a quote from a Manitoba case. "Unions must be particularly alert and sensitive to an employee's disability and the employment interests at stake in cases concerning the application of human rights principles, including the duty to accommodate." So labor boards are looking to see these things: greater scrutiny when you have a human rights issue and a grievance, a different approach, extra effort, proactivity, and alertness. And also, of course, sensitivity. Now, the Canada Board has developed specific criteria for dealing with complaints that a union has not represented a member properly who had a disability and was seeking accommodation. And I think those criteria are instructive. The first one you'll see is whether the union's intervention was reasonable when the employer failed to implement appropriate accommodation measures. Secondly, whether the quality of the process that allowed the union to come to its conclusion was reasonable. 3, whether the union went beyond its usual procedures and applied an extra measure of care representing the employee. And 4, whether the union applied an extra measure of assertiveness in dealing with the employer. And you'll note that those criteria all deal with the process. Labor boards hold unions to a higher standard in BFR cases where there are human rights issues, but they're still focused on the process. They're not looking at whether the union came to the right conclusion. They're looking at whether the union followed an appropriate process for that type of issue. And I'm just going to go through with you quickly some expectations that the Manitoba Labor Relations Board spelled out for union reps dealing with human rights issues. 1, they said that the reps need to ensure that the disabled employee understands his or her rights and responsibilities. 2, the union rep follows a process that recognizes the employee's disability. 3, that the rep assists the employee with obtaining necessary medical reports and circumstances. So you usually need medical evidence if the employer is denying that the person has a disability or arguing about whether they need accommodation. And that's not so easy to get. Most people need some assistance in order to pull the right information out of their doctor. Union reps need to consider the relevant medical reports and the merits of the case. They need to help the member get the evidence, and then they need to look hard at the evidence. They can't just go by their own impressions. And union reps need to get help if they're dealing with an issue that's beyond their competence and experience. So if you're a union rep dealing with a human rights issue for the first time and you're not entirely comfortable with it, at least in Manitoba, you would be expected to get a legal opinion, and I would suggest to you that that's also good advice for reps in Ontario. I want to take you through, just through one case in detail to give you a flavor for what can go wrong for a union rep handling a duty to accommodate issue. So I'm going to take the Bingley case as an example. This is a case involving the Teamsters and Purolator Courier. The complainant, Grace Bingley, was a driver for Purolator Courier, and she was diagnosed with skin cancer. She had to have surgery to remove the cancer, and after the surgery, she went back to work with a couple of restrictions. In particular, her doctor said she could not work more than 8 hours a day. And the average shift at that point was 9.5 hours. So she was only back for a few days before the employer actually removed her from the workplace and said, because you can't work a 9.5-hour shift, you are unfit to work. So they didn't fire her, but they put her on leave when she really wanted to be working. And so she went to her union rep and asked the rep to file a grievance, and the rep ultimately did, but only after she threatened to file a duty of fair representation complaint. So a grievance was filed. The employer made various proposals to Ms. Bingley over the course of a year for accommodation at work, and the union rep would basically acted as a go-between. He would relay the proposals to Ms. Bingley and then bring back her response to the employer. But all the proposals came from the employer. They were formulated by the employer, and they all violated her restrictions. They all involved her working more than 8 hours. So she didn't actually get back to work for a full year. After a year, her doctor removed that particular restriction, and then she returned to work. And when she came back, she said to the union, I want you to grieve. I want you to, well, sorry, they had grieved. She said, I want you to take my grievance to arbitration because I need compensation for all the time that I was off when I shouldn't have been off because she had a disability. As Lisa explained, a temporary illness still qualifies as a disability. And because she had a disability, her employer had an obligation to accommodate her. And she was saying they didn't accommodate her up to the point of undue hardship. So she said she wanted an arbitration. And the union responded, well, that they weren't going to take her case to arbitration because they tended to agree with the employer. They thought that she'd been unreasonable. So they wouldn't take her grievance to arbitration. She went to the Canada Board and filed a duty of fair representation complaint against the union. And she was successful. And I think the union was quite shocked, but she won. Now, the Canada Board had some good things to say about the union rep who handled Ms. Bingley's case. They noted that he was emailing her at 11 o'clock at night and even later, so he wasn't lazy. He was sympathetic, and he obviously spent a lot of time on her case, but he lacked any human rights training or human rights background. So he really wasn't of much assistance to Ms. Bingley. And I'll just go through with you very quickly some of the criticisms that the Canada Board had. First of all, they were critical because the griever had to actually threaten the DFR in order to get a grievance filed. They were critical of the rep because he relied solely on the collective agreement. He never referenced the Human Rights Code. He didn't say, you have violated Section 5 of the Human Rights Code. And he ought to have said that because, as Lisa explained, you can enforce the Human Rights Code through a grievance as if the provisions of the code were part of the collective agreement. But he failed to do that. Also, he relied entirely on the employer to come up with proposals for modified work. And he didn't come up with any of his own, and yet he had information that would have assisted him in helping Ms. Bingley because partway through the year, Purelator Courier introduced shifts that were shorter than 9.5 hours. They had shifts of 8 hours or less. Yet he never said, hey, Purelator, what's going on here? You've got shifts available now that meet her restrictions. Why aren't you giving Grace any of those shifts? So he never, he didn't really engaged in his own analysis, and he didn't challenge the employer's analysis. And another big mistake that he made was substituting his own views for the medical evidence. He didn't really think that having skin cancer was that big a deal and that this 8-hour restriction was valid, even though he had medical reports from Grace's doctor saying she needs this restriction. He ought to have paid more attention to those medical reports and taken them more seriously. And another big mistake that he made was he gave up too quickly in negotiations. Grace asked for something like $40,000 in compensation. The employer said no. So what did the union rep do? He came back and said, well, the employer said no. He never went back to the employer and said, well, how about 30? How about 35? He didn't try and negotiate. And that was another mistake on his part. So you're probably wondering, well, what did the Canada Board do to this poor rep, or what did they do for Ms. Bingley? I'll tell you what the remedies were. First of all, they directed the parties, which included Purelator Courier, to meet with Ms. Bingley and a mediator. They directed the union to allow Ms. Bingley to select counsel, legal counsel, to represent her in the mediation, and they directed the Teamsters Union to pay for her legal counsel. Also, they awarded her $5,000 in costs for the expenses she had just in litigating her DFR, and they remained seized, and they asked the parties to report back to the Canada Board within 30 days if they weren't able to resolve all of the issues. And I don't see any follow-up decision, so I'm assuming that at that stage they did manage to solve their issues. So, what can we learn from the Bingley case? Well, first of all, I would say a union rep needs to be able to recognize a human rights issue. So you need to be familiar with the concepts that Lisa discussed. And you need to be able to flag human rights issues, both for members and for employers. You need to be able to say to someone like Ms. Bingley, hey, you have a disability, you have a right to accommodation. And to Ms. Bingley's employer, hey, she has a disability, you have a duty to accommodate her. And you need to be able to handle those human rights issues appropriately. So that means using extra care in looking at the facts and communicating with the grievor, and extra assertiveness in dealing with the employer. Now, another piece of advice I would give you is also to document what you're doing as you go along, so that you can rely on a defense that the Canada Board mentioned in the Bingley case, but which wasn't actually available to that particular rep, and it's called the good faith advice defense. So if you know your stuff and you give a complainant or griever like Ms. Bingley good advice and she simply ignores your advice, as long as you've documented that, then if she is dissatisfied with the outcome and files a complaint against you later on, you'll be able to defend yourself by showing that you did everything that the Labour Board would expect you to do with a human rights issue. And lastly, I agree with the Manitoba Board, you need to get help if you're unsure how to proceed. Don't be too hard on yourself if you are unsure, because human rights issues are complicated. Discrimination isn't always obvious, and solutions aren't always obvious. So it is a pretty tall order for union reps to deal with human rights issues. Unions definitely need to invest in training in this area for the representatives. And as I said, union reps need to ask for help when they're unsure and to have access to help through their union. If you find yourself in a situation where you have a grievance that has human rights issues associated with it and you're unsure about how to proceed, you're more than welcome to give Lisa or I a call. We'd be happy to help you with it. And that brings me to the end of my presentation.